Yeah. Just so you know, it's probably like you're acting like you have no idea what I'm talking about. Did you get an email from me today? You know, the playing stupid on the part of the sheriff's and police department. Every time that you act stupid, as in you don't know, you're going to go to prison. Now, not only are you fucking up the life of Judge Landis, yes. See, I could go to court tomorrow. And then you'd make up some bullshit about, well, he has to appear so we can dismiss this. And I would say, actually, you have to remove it today so I don't have to appear. My appointed counsel could not be appointed to me because you did not give me personally summons and the criminal complaint. You did not read me my Miranda rights. Now, for every cop in the United States of fucking America, I want you to understand that without those rights being read to me and somebody in police departments actually saying that they interviewed me, questioned me, or wanted to know where I was at, this criminal complaint should not be used with homeless people. It should be used with executives that can afford an attorney, yes, so that they can answer the accusations in written legalese, yes. Now, these factual and procedural history, yes. Life imprisonment, Now, what's interesting, yes, is that in reading Rules 4 of the rules governing Section 2254 cases, if it plainly appears from the petition and any attached exhibits that the petitioner is not entitled to relief in the district court, the judge must dismiss the petition and direct the clerk to notify the petitioner. Now, because the determination of timeliness of Johnson's petition is clear from the petition, a response was not ordered. Yes. Exactly when do I get a response? Now, Johnson filed a petition for allowance of appeal, blah, 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 blah. Johnson sought further results and petitioned for a writ of habeas corpus. More than 4 years after the sentence became final, petition alleges multiple grounds of ineffective assistance of counsel. Can you have any more ineffective assistance of counsel than counsel that could not be appointed to you? Let me ask you again. Let's say you're a public defender. Criminal complaint. You appear in court at the arraignment and you represent me for the last 16 months. Yeah. You find out that I have not been read my rights and no one in the police departments anywhere charges me with any crime. You decide that I'm going to a cell hearing tomorrow because you just have to have the fucking hearing. Now, this is multiple grounds of ineffective assistance of counsel. When you can't be appointed to a person because they were not read their rights and there was no charging language of law enforcement, I don't think you could be more ineffective because there was no legal obligation to have you as my counsel. Now, his guilty plea was involuntary. Yes. Let's look at it. Let's say that I answer the complaint and I said, no, actually, I wasn't there. Yeah. And I wasn't cyber stalking, and I produced all the emails that I sent on June 16th of 2017. And then the prosecuting attorney shows me an email that wasn't sent from any of my email accounts. Now, I would have had access to the evidence. Yes, yes, yes. And I said, well, that's not my email account. I don't know who sent that pooch. Now, I just put the emails yesterday. Now, you say that there's no way to defend yourself against the count one cyber stalking. Well, there sure the fuck is. I can give you emails from that day. Now, multiple grounds of ineffective assistance of counsel. Just so you know, Jack, if I go to court tomorrow, right, and you're there and you're representing me, everything that you've represented is ineffective counsel every fucking time because the court had no legal right to appoint counsel. And just as crisis responder says that I'm crazy, it's an accusation of crime. It has nothing to do. These are crimes. I'm not on trial for being mentally ill, mentally competent. Yes, I'm actually on trial because of this fucking thing right here. This, right. See this RCW 9.92.020? Yes. I'm on trial for both pursuant to 26.50.110. Yes. And 9.92.020. The whole concept that you're going to believe a crisis responder instead of the accused, yeah, completely disregards the rights of those that have not had their rights read to them. Now I know, okay, as a citizen of the United States, the judge has an obligation to not think of me as a crazy individual for knowing where the fuck I'm going.